Wish to hear you on ground 1, nor on ground 4, which wasn't really separately pursued, but we would like to hear you on grounds 2 and 3, the Hardiel Singh.
I'm grateful, my lord. Starting with ground 2.
Yes.
Then. Oh, before I start, perhaps it would be helpful. My Lord Justice Lewis mentioned a number of points at which he wished to have details about.
Yes.
And I can give him some of those details, but not all of them. If I can find my note, that would help. Oh, I'm so sorry. I dropped it over the lunch. And
you can come back to it if you like.
Or... I found it. Sorry.
Yes, right.
Sorry about that. My lord, the first question was, you were concerned about what was supplied.
Yes.
The two different biodata forms. There's the one in the supplementary bundle at page 146, and there's the one in the supplementary bundle at page 581. Just for your note, excuse me, Miss Buckle deals with this at page 38A to 39D of the supplementary bundle. Secondly, you asked about an EU letter. Unfortunately, it's not possible to know what was on that letter. Miss Buckle addressed that at the time in her evidence, again in the supplementary bundle, page 29A to H. And finally, there's a policy document at page 379 of the supplementary bundle, the undated single page. And your lordship asked what that was. Unfortunately, it's not clear. Miss Buckle deals with that at page 36 of her evidence at D to H. It's not dated. Miss Buckle said she had probably seen it before, and she said that it probably was a returns logistics page. And I'm afraid that's as much detail as I'm able to.
What was the page number of the single sheet?
So the page number of her evidence or the policy?
Buckle 36 deals with the single sheet at.
And so it's page 36 D to H.
Yes.
Miss Buckle deals with it.
379.
D to H. Right. And it's the policy of page 379.
Yes.
So.
Thank you. That was our shopping list from this morning. Right.
So that's that part. If we go on then to Hardiel Singh 2. Round 2 at least. The appellant argues that the judge erred in finding, so sorry, that the appellant's detention complied with Hardiel Singh 1. This is at paragraph 30B and 33 to 36 of the appellant's skeleton. The Secretary of State responds to this in detail, paragraphs 50 to 60 of the Secretary of State's skeleton. In terms of the argument itself, the court is, of course, very well aware of the law. Hardiel Singh 1 suggests that the Secretary of State must intend to deport and the detention must be for the purpose of deportation. And you were taken to the restatement of the Crown on the Application of I principles in Lumba, paragraph 22. In my submission, this is clearly targeted at preventing the use of immigration detention for ancillary purposes. And you can see the way in which this has been described in the authority AA. You don't need to turn it up, but for your note, it's authorities tab 5 of paragraph 40, and then that's a decision of Mr. Justice Cranston, and also HXA, authorities tab 6 at paragraph 178, which is a decision of Mr. Justice King. So in my submission, there's no suggestion. There is no suggestion that the Secretary of State breached the Hardiel Singh 1 principle in this way. For example, seeking to detain someone in order to prevent them from carrying out a criminal offence or committing some kind of national security incident or whatever. The purpose of detaining people is for the purposes of deportation. Now, what the appellant appears to argue is that the judge erred in finding Hardiel Singh 1 to be satisfied in circumstances where the Secretary of State did not comply with the stated policy condition for an EU letter, and where the Secretary of State had secured information from the Ugandan High Commission on the basis of materially misleading information. And the logic of that appears to be that insofar as the intention is to remove, against that background, it becomes an intention to remove unlawfully, and on that basis it cannot be an intention to deport, properly understood. And so, as a result of those public law errors, the first Hardiel Singh 1 principle is breached. I hope that's fair. That's as I understand the argument to be put. In short, the Secretary of State submits in response that, with the greatest of respect, that analysis must be misconceived in law and is unsustainable on the facts. Starting the straightforward point that, having considered all the evidence and submissions of the parties in the judgment at paragraphs 172 to 174, the judge found in terms and without hesitation, quotation, that the appellant intended, the Secretary of State intended to deport the appellant, only used the power to detain for that purpose, and had no intention to act unlawfully. The conclusion itself is in the judgment of paragraph 175. And in my submission, that's a complete answer to the appellant's claim.
Well, the problem is that needs a bit of unpacking. Is there or is there not a separate requirement that under Hardiel 1 for an intention to remove unlawfully? I understand that if you're not doing it for deportation but for another purpose, that is unlawful. But if you're doing it for deportation, it is said that that would involve a failure to comply with policy guidance or not involve full disclosure of details, that might render something unlawful. But does it render the intention unlawful, or does it go to the reasonableness of the period or the effectiveness to deport?
I was going to say precisely, my lord. In my submission, it goes to the second of those. It doesn't go to Hardiel Singh 1. The question for Hardiel Singh 1 is, what is the intention of the decision maker? And if the intention of the decision maker is to deport, in my submission, it can't be right that several years after the event, it's possible to go back to try and unpack the intention of the decision maker. And if there's some public law, indeed technical public law error, of which they were not aware, that negatives their intention. So, point number one, I would suggest, on the facts, the appellant simply didn't make that out. The judge wasn't with them on that and didn't accept that that was the relevant intention. And I would suggest that there's been nothing put before this court capable of disturbing the judge's finding, clear finding, in that regard. But even if that hadn't been set out as clearly as it was, as a matter of legal principle, this is not a statutory precondition. These are common law principles set out to describe and to control the circumstances in which the Secretary of State can properly detain someone. And the first of those in my submission is simply to say you cannot detain for an ancillary purpose. There was no ancillary purpose. There's no doubt and no suggestion in my submission anywhere throughout this bundle that the Secretary of State intended to, and indeed did, deport the appellant. It deported the appellant with the agreement of the High Commission in London. The fact that it didn't succeed and the appellant had to be returned and that the Secretary of State then had to continue to see whether or not steps could be taken to facilitate deportation in the future, in my submission is neither here nor there. The principle is a straightforward one. I would invite the court to find that it should be applied in the straightforward way that I would suggest it's always been applied before. And it simply doesn't admit of the gloss in my submission that the appellants would ask you to put on it. The appellants themselves then go on in the alternative to suggest that the judge erred in finding that he was not required to make findings as to whether the Secretary of State had failed to act in accordance with policy and had sought approval from the Ugandan High Commission on the basis of material known to be materially misleading, and third, that he'd failed to give adequate reasons. But in my submission, the judge's reasoning is absolutely clear from the judgment. In addition to the paragraphs I've already cited, the judge did give reasons. In paragraph 190, subsection 4 and 206, the judge accepted that the appellant's place of birth was not confirmed to the Secretary of State until after he had been released from detention. And as such, the Secretary of State could not have intended to deceive anyone. And at the judgment, paragraph 201 and 190, subsections 1 to 3, where the judge accepted that there had been no breach of policy.
Which paragraph is that, sir?
That's paragraph 201, and it references 191 and 3, or 1, 2, 3, I should say. So, I would submit that these were findings that it was plainly open to the judge to make. The appellants in this case haven't sought to give, I would suggest, the kinds of reasons or to make the kinds of challenge that would enable this court to set those findings of the first instance judge aside. This isn't a first instance hearing, this is an appeal. The appellants have to identify some error in the judge's reasoning on these points, and in my submission they simply haven't done so. Indeed, to a large extent, they haven't attempted to do so. But if they were to do so, I would say that, invite the court to find that the judge was plainly entitled to come to these conclusions. In terms of the Uganda-specific policies, the policy which my lord has already referred to at page 379 of the supplementary bundle, plainly says removal of a Ugandan national on an EU letter may only proceed if the following criteria are met. And the first of those is, there's no dispute or doubt over their Ugandan nationality. Well, there was no dispute or doubt over the appellant's nationality at all. The Secretary of State was clear that he was a Ugandan national. And that is set out throughout the documents. There was a dispute as to where the appellant was born. There's no doubt about that. Indeed, Ms. Buckle says categorically in her evidence that she wasn't sure she was ever certain where the appellant was born, and this is referenced in the first-year tribunal decision as well. But there was never any doubt that the appellant was a Ugandan national. Not only had he stated that he was a Ugandan national, that his mother had stated that he was a Ugandan national, he had a Ugandan passport, and the Secretary of State's analysis of the law was that merely being born in the United Kingdom could not give you British citizenship. As your lordships and my lady have mentioned on several occasions, there was no evidence before the judge capable of disturbing, undermining those factors. Foreign nationality is a matter of fact. It's a matter of foreign law. There was simply no evidence at all in my submission that could have allowed the judge, and I'd almost put it as high as that could have allowed the judge to come to a conclusion that the appellant was not Ugandan. But in any event, I don't have to go that high. What the appellant has to show is that the judge could not have reached those conclusions. And in my submission, they go nowhere near to achieving that. So I would submit there is simply no basis at all for disturbing the judge's findings on the basis of Hardiel Singh 1. those are my submissions on Hardil Singh 1, unless I can assist you further.
Hardil Singh 2.
Thank you. So moving on to Hardil Singh 2. The appellant, so this is the appellant's ground 3. The appellant takes Hardil Singh 2 and 3 together, obviously, in ground 3. And the appellant argues that the judge erred in finding that Hardil Singh's 2 and 3 were satisfied. And the appellant supports this claim with 21 instances of alleged failures to take material matters into account, failure to give adequate reasons, and/or failures to make necessary findings of fact. In my submission, the Court of Appeal may find this on its face to be rather striking, given that the claim was heard by a highly experienced High Court judge, and that the matters in issue here, Hardil Singh's 2 and 3, are straightforward and familiar to judges working in this jurisdiction. The Secretary of State's response is set out in detail in the Secretary of State's appeal skeleton, paragraph 64 to 73. And they should, if you've got the updated versions of the appellant skeleton and the respondent skeleton, track each other directly. And hopefully that makes it easy for the court to compare the relevant claim together with what the Secretary of State says about it.
What do you say in particular about the fact that when he got back here from Entebbe, a brief 2-day trip there and back, you held on to him in detention till June, I think, basically. By the time he came back, you knew that they weren't letting him in. So why were you trying again? Why was it reasonable then?
My lord, I would submit that it couldn't be put as high as that.
Oh.
We know that the appellant had, that the High Commission in the United Kingdom had indicated that they would be content for the appellant to be returned to Uganda, and he was. We know that officials at Entebbe, it's not clear how far up that went, it may just have been entry clearance officers, whatever, refused to admit the appellant after he had carried with him and handed over a copy of his birth certificate, apparently to frustrate removal. In my submission, it cannot be inferred from that if the appellant were to be removed again, that if further steps were taken with the Ugandan authorities to address the relevant matter, that the appellant would not be able to be removed. And in fact, if your lordship turns up the deportation, the 2019 deportation decision, if I can find it, there's a useful summary of what the Secretary of State was aware of.
Sorry, Mr. Deacon, I want to go back to something you said a moment ago. You said he handed over his birth certificate apparently to frustrate removal. Are you saying he shouldn't have handed over his birth certificate?
No, not at all. The point is simply that there was a removal that took place, which the appellant did not want to take place.
Yes.
And it appears that the appellant took steps, whether they were appropriate or not, in order to make that removal as... It appears to be the case that the appellant took steps in order to frustrate that removal. That's a matter for the...
But he can only frustrate it because he's not born in Uganda, he's born here. And I mean, you yourself in your notes, not you personally, the Home Office, had said they were going to courier the birth certificate for reasons that we don't know. He didn't. So there's nothing wrong about that. You could say that the appellant was doing what the Home Office should have done. He was finally telling the they haven't done their jobs properly. I'm born in Britain, and they said, well, hold on, that may change things, and sent him back.
Certainly. So, a few points. Assuming that to be the case, in my submission, it doesn't affect the lawfulness of holding Mr. Johnson on return. And I'll find the document in the...
That document would be helpful, actually.
So it's the 2019 decision, which is a tab 30 of the bundle.
No, we haven't got tabs except for
Of the full bundle.
That's just pages.
And what you see at the end of it,
Sorry, you'll have to give us the page number of the call, but I'm so sorry, but we don't have tabs.
page 397.
I'm very fortunate I do have to have, so, but 397.
397, my lady.
Right.
397.
So,
This is the stateless decision in November, 20th November 2019.
exactly. But what you can see is a helpful chronology of the relevant facts. And what the Secretary of State is saying here, if we start, we don't have to start at the beginning. If we start at the top of the page at 397, we can say on the 9th of March 2015, there's a note from Country Returns. Operation and Strategy states the UGA HC are no longer accepting EULs. So EU letters stop at that point. The Secretary of State moves to ETDs. And you can see on the 17th of April 2015, an ETD was submitted to the Ugandan.
Again, that begs so many things, actually. We've been told right up until I see this one that the ETD process, the emergency travel document process, has been suspended. That's why they use the the European Union letter. Now we're told that they can't use the European Union letter because it's not worked, and they've switched to something that all the other documents Mr. Metzger showed us said had been suspended. Or had they been reinstated?
My lord, I don't know, but what I do know is it must have been reinstated because on the 29th of April 2015, the appellant attends the Ugandan High Commission for a face-to-face interview. And if the process had been completely suspended, presumably that wouldn't have happened. And after that meeting, all of this was addressed in the first instance. After that meeting, the Secretary of State then chases an answer from the Ugandan authorities as to what the result of that meeting, what the outcome of that meeting was. And we can see on the 25th of June 2015, a note on SID says the High Commission made clear that the subject will not be accepted again to Uganda, and their position on Mr. Johnson has not changed as per last year when he was removed to Uganda and rejected at the point of entry. And then the next month, on the 16th of July 2015, there's another SID note states, contacted Returns Logistics who advised the Ugandan High Commission will not accept anyone back into Uganda if they were born in the UK or have a long period of residence in the UK. Now, if the Secretary of State had held Mr. Johnson past that date, then, in my submission, there would be serious difficulties for the Secretary of State in defending a Hardeel Singh 2 or 3 claim. And indeed, that's what Mr. Justice Sweeney pointed to when at the end of his judgment he said he recognises how long the detention had gone on for and his concern about it coming to an end. But the fact of the matter was that is after the appellant had been released. So my submission is, in answer to your question, I'm sorry for the long-winded way in which I've done it, but when the appellant was returned, it was not clear that he was not returnable. The Secretary of State was entitled to and did take steps to ascertain whether or not there was a mechanism for removing the appellant to Uganda. My first point is that this was canvassed at first instance, and Mr. Justice Sweeney, having considered the facts and the relevant material, took the view that in all the circumstances, given Mr. Johnson's offending history and the risks posed, the Secretary of State's decision was reasonable. So that's point number one. And point number two, I would suggest that the appellants have pointed to nothing to suggest that it was so unreasonable, we can come on to the law in a minute, that it was so unreasonable, even if this court may decide that it would have taken a different view, that it would be appropriate to overturn the first instance judge's finding or evaluation on the facts as found. I hope that answers your Lordship's question.
It's actually in 219. He says that it had been, the ETD process had been reinstituted in March 2015, and CRROS, whatever they are, advised completion of an ETD, emergency travel document, which they did, and then that was submitted on the 14th of April. The next sentence in 221 says on the 17th, that must be February, it must be the 17th of April, presumably. And then there was a face-to-face interview. And they understood that the issue had been referred to the authorities in Uganda. And before they got the final decision, they take the decision 225 having chased for 7 weeks and having not got an answer, they let him out of detention on bail. Yeah.
Yes, yes,
Okay.
yes.
So you say it's all in there.
We say it was canvassed before the judge. It was considered by the judge. It was a proper evaluative decision that was open to the first instance judge to make, and on that basis, I would suggest that's a complete answer to that element, the post-return element of Mr. Johnson's detention. And indeed, insofar as it's material, the appellants don't challenge the detention on that basis. The challenges that they run in their ground 3 are reasons challenges, essentially. They aren't. This was a perverse decision of the first instance judge, and here are the documents that support that.
Your last starter for 10. What does CROS stand for? Before you get the bonus question.
If I may turn to someone behind me.
Oh, okay.
CRS.
Don't worry.
I'm so sorry.
Don't worry. We'll get the bonus picture row later. That's all right.
But if I may, just turning back to the grounds 2 and 3, the general points, which I think it would be helpful to make. Obviously, Hardware 2 and 3 deal with the reasonableness of the length of the detention. The deportee may only be detained for a period that is reasonable in all the circumstances, 2, and 3, if before the expiry of a reasonable period, it becomes apparent that the Secretary of State will not be able to effect deportation within a reasonable period and should not seek to exercise his power of detention. So they, just to follow on the point that I was making, they concern evaluative findings on the facts, and in my submission in accordance with paragraph 76 of Prescott, Authorities Bundle tab 616, they can't be overturned or shouldn't be overturned absent some identifiable flaw in the judge's reasoning. In my submission, this is a fairly hard-edged test, and that decisions of first instance judges should not be set aside lightly, and the authority for that is Prescott again at paragraph 77 to 78. None of this will be new to this court, but I thought it was important to flag it. The appellant therefore has to identify in my submission the particular flaw on which the appellant relied, and general statements of disagreement cannot be enough to support a ground of appeal in my submission. Secondly, and for the same reason, where the appellant alleges that the judge failed to deal with an issue, the addition of properly or at all, or any adequate consideration are not going to be sufficient to save an allegation if the judge did in fact deal with the point. If the appellant wishes to argue that the judge didn't deal with it adequately, in my submission it's important for the appellant to highlight how the judge failed to deal with the point properly and how the failure is material to the decision. And I suggest that hasn't been done here. As set out in the appellant's written case, the repeated use of properly or at all or adequately at all serve principally to indicate that the judge did deal with that point. But
Speaking for myself, it seems to me that you're almost arguing ground 4 on which we said we didn't need to hear from you.
The relevant paragraphs, my lord, are 37B, 2, 3, 4, 5, 11 and 12, which are the grounds 2 and 3 in that phrase. But I won't press the point. I just wanted to flag it because it's that all the arguments, or a lot of them, are couched in that alternative. The argument wasn't dealt with by the judge, but if it was dealt with by the judge, it wasn't dealt with properly. And I would
the
say,
essential point is what they are saying is, we don't agree with the judge below, we'd like you to take a different decision, and you're saying we must be satisfied that the judge was wrong, and that we can't on these findings, you say.
thank you.
That's essentially it, isn't it?
That's exactly. Thirdly, and again, your lordships and my lady will be well aware of the authorities on reasons challenges. I don't need to take you to the relevant authorities. There are 2 of them in the bundle. I simply flag up Lord Justice Mayall's observations in Symmetra Authorities, tab 17, paragraph 46, and Sir James Mundy's observations in C,
Yes.
which the Authorities bundle 14, paragraph 39. And then finally, there's a point by way of introduction, is that the appellant states in the skeleton argument of paragraph 37b9(1), and it was repeated in oral submissions, that the first instance judge appears to have, and this is the quote, covered the evidence there referenced by the cloak of his determination not to consider the question of the material misdirection of the Ugandan authorities. This ground is addressed in the Secretary of State's skeleton, in particular at paragraph 71(9). And the court will note that following receipt of the Secretary of State's skeleton argument, the appellant has now corrected his assertion that the judge failed to deal with the 9th of December note. But the point which I wanted to make by way of general point, and while I expect it was a rhetorical flourish, if that's wrong, and if the appellant's suggestion is that Mr. Justice Sweeney deliberately sought to ignore matters that he knew to be material, then that would be a very striking claim indeed, and one that the Secretary of State submits would be wholly unwarranted and unsustainable in light of the judgment. It's also the kind of assertion that would need the most particular care before it was advanced. The appellant makes no attempt to do that, and I would invite this court to reject any such suggestion emphatically.
It sounds like an allegation of a failure to deal with the case impartially. He's determined not to find for the appellant come hell or high water, is what it's saying in English.
If that is what the appellant is asserting, then I would suggest that that is a point that would need to be made explicitly and argued for, and to the extent that it's not, then that could be clarified.
I don't think it is
Not
what you
arguing
were
bias
saying.
in any regard at all.
No, thank you very much.
Very grateful. So the issue now comes down to dealing with the 21 points. And what I had proposed to do was to say to this court that I'd set out my answers to the points with extensive references, and that unless there were particular concerns that the court had, it wouldn't be a good use of your time for me to go through it line by line. But I'm delighted to deal with points if that would be of assistance.
Well, you say that the the exercise is misconceived on the principles you say derive from many cases such as Justice Mayall's in Sinatra and Sir James Munby and We See a Child.
I'm sorry.
But if the general answer that the exercise is misconceived is not sufficient, then your answer to the 21 points is to be found in your skeleton argument.
Yes, my lord.
And Mr. Metzer didn't take us through the 21 points either, partly because of lack of time, but
Yes, to be fair to him, I think there was very little time for him.
I think we can probably take the written submissions on one side as answering the written submissions on the other.
I'm very grateful. My lord, there was one other point which I didn't propose to deal with to address the court in any detail on, and that was the question about res judicata. It seems to me that it's not necessary for the Secretary of State to address this court on that point for a number of reasons. So to explain the stop jumping around, it deals with ground one.
It's only if you lose on ground one.
Exactly, and if it's not necessary if it's not necessary for me to address you on ground one, it seems to me again that it would be a waste of your time to deal with an obiter point.
That's correct.
I'm very grateful. Unless I can assist you further. Thank you.
Thank you very much, Mr. Metzer.
Lord, just I think 3 or 4 very short points. First of all, I wonder if we could just go to I think it's really on targets in 2 and 3.
Yes.
It's page 360. It's really a point that was touched upon just before the short adjournment. It's really the point about what was known, and it's the third paragraph. Checks have been carried out with intel which confirm there's a corresponding entry to the birth certificate. Information has still been requested from Central Middle Hospital Records Department, who confirmed by phone that birth was registered at the hospital. A written request by written confirmation, so it couldn't be said, and it couldn't be said that there was no evidence of a response. The point being limited only to the written confirmation, but there was confirmation by phone of the position, and therefore it was not right to say that the court did not have evidence in terms of.
And what did Mr. Justice Sweeney say? Can you just take me to the paragraph?
Yes.
I thought he said no confirmation, which could mean no written confirmation as in the note. If he said no evidence, then it's different.
It's 206 of the judgment. He references at 206 Mr. Deacon's arguments and reasons at paragraphs 189, 194 and 192 to 198 do tell him. And if you look at 194B,
I looked at 207, but you want me to look at another one? I'm so sorry.
if you look at 190B, just give me 1 moment. At page 203, 194B.
Oh, I see. Yes.
There was no evidence to support the claimant's contention that the Ugandan authorities investigations to the birth certificate were commenced. CID notes recorded the investigation. No evidence of a response to that request. That's factually wrong. And it's crucial in our respectfuls, and it's highly significant. There was a response. There wasn't a written response. We, of course, accept that. But there was a response by phone, as is clear from the evidence. And therefore, the point advanced at 194B was not correct, but was relied upon by the trial judge.
Hold on, can I just follow that through? That was the 17th of January 2014, and this is Mr. Deacon's submission, and the document you've just shown us was the 4th of February. And then what does Mr. Justice Sweeney actually say about it?
He says, if you go back, he adopts the 206. I found Mr. Deacon's arguments and reasons as summarised, and he mentions 194 specifically to be telling. That's paragraph 206, where 194 says there was no confirmation of the claimant's place of birth until the 20th of July 2015. So the submission, in our greatest respect to my own friend, was not wholly accurate, but was relied upon, and specifically so, by the learned judge.
Reading technically, he says it was telling, and you go to 207, last 5 lines, against that background, some steps had already been taken to check the validity of the UK birth certificate, and albeit that they had come to nothing by that stage. And that was true, wasn't it? Because he's talking about the 27th of January then. We don't know what the phone call was, saying that it must have been before the 17th of February. I mean, it seems terribly pernickety to say this turns on the fact that Mr. Deacon said no evidence, and Mr. Justice Sweeney said they came to nothing by the 7th of January.
Retrospect, I don't think it's pernickety.
Mm.
Unfortunately, I think lawyers, all lawyers, are careful on detail, and I think, frankly, that's a good thing, not a bad thing. This is just wrong. I mean, I'm sorry to put it as bluntly as it is, but in our respectful submission, there was no written confirmation, but it is not accurate to say there was no response to.
If we
And
usually accurate, what date was the telephone call? Do we know?
I think we do. We probably need to go back.
Justice Sweeney deals with it in paragraph 18.
18.
Yes, I'm grateful. Well, I'm not sure that does help actually. 360 is in February. I don't think it does deal with it actually. From the document at 360, it would appear that this must be February, because if you look to page 362, which is the end of the document, 360 starts, that Mr. Peterson records 4th of February. So
Sorry,
it's certainly
what
buying the 4th of February.
I'm getting lost, Mr. Metzner.
I'm
What
sorry, my
is
lord.
the critical phone call, by whom, to whom, and on what date that you're referring to?
We don't know the precise date, but Mr. Justice Sweeney, and I'm sorry to say, my little friend, I don't think that paragraph that we were drawn to makes reference to this. We know it must have been by the date, before the date of the note, which is the 4th of February.
Sorry, phone call from whom to whom?
This is from the paragraph at 360. Somebody confirmed by phone from Central Middlesex Hospital Records Department. I think the word is who have confirmed by phone.
This seems to be a historical narrative, and it seems to be recording events. So it looks as if in February they were recording something that had happened prior to the 17th of January.
I don't know if we can say. I wouldn't have thought so, but because it looks like this would have been a response to the inquiry made of the hospital. So we can't pinpoint a date.
No, if you look at page 358, there's a heading underlined immigration history, and it goes through all of that chronologically. And on page 360, we go to 2013 at the top, and the third paragraph is without a date to check. The fourth paragraph, we return to the chronology. So all of this appears to be an historic chronology, which, taken at face value, appears to suggest that a telephone call was made to an unknown person at the hospital, and a request was made for written confirmation, but no reply had been received. That seems to be the position prior to January 2014.
Well, my lord,
That
I'm
not
sorry
right?
to belabor the point. I don't think that is a fair characterisation of the likely scenario, because this was a request made of the Central Middlesex Hospital for clarification in relation to the birth certificate, and one has to ask who was making that inquiry and why.
Because on the 9th of January, as you showed us this morning, somebody in the Home Office had made a note noting about the discrepancy.
Yeah.
And
So
we know he's coming to the end of his tariff period, his custodial period, and they're getting ready to send him back.
Yes.
So why is it unlikely that somebody telephoned the hospital at about that time?
No, it's not. It almost certainly, I would respectfully agree, was sometime in the middle of January 2014. I agree.
I think I see how you put it now. That a phone call is made to the Central Middlesex Hospital. Do you have a record of a baby of this name being born on whatever date? And they say yes, and that tends to support the genuineness of the birth certificate saying he was born at the Central Middlesex Hospital.
Yes.
Right.
And
I understand that, but and you say that that was relevant to the Hardiel Singh claim.
I do, my lord,
Right.
yes.
Okay.
And I think, I don't want to belabor the point any further than I have, but whether it was on before the 17th of January, it was certainly probably in that week time between about the 10th and the 17th of January. It certainly is material to the information available at and around the 17th of January, albeit there was no written confirmation. There was evidence of a response confirming by phone that he was indeed born at that hospital, and there's no reference to that in the judgment.
Okay, that was the first point.
That's the first point. I'm sorry,
Yes.
it's a little longer
No,
than I
right.
thought. Just at 585 of the, I think this point is really covered by Lord Justice Lewis, but we just want to make sure that everybody understands what happened on the 3rd and the 11th of March 2015. At 585, it appears, supplementary bundle, I don't know if I said that, 585 supplementary bundle. We can see there a reference to the 3rd of March 2015, spoke to Tim Delaloglo in Cross, who confirmed that at present EUL, with EU letters, ETD for Uganda are, that's plural, on pause. Removal talks taking place this week. Tim has agreed to inquire about this case in particular. So that appears to be the position. The process has been suspended for both ETD and EUL.
What do you say about paragraph 219? It says precisely that on the 3rd of March, this is 219 of the judgment.
Yeah.
What you just showed us, EUL, ETD removals were on hold. Shortly thereafter, and in respect of the issue, saying that an agreement had reached to suspend the union letters and to institute the ETD process. That's the primary finding of fact. And what's wrong with that then?
What we say about that on the 11th of March 2015 review, the judge, learned judge, as my lord rightly observed, says the only barrier to the appellant's removal is the securing of an ETD, and we've gone back, we don't need to go there, it's 290 of the supplementary bundle, in relation to the apparent non-appreciation of the respondent as to the requirement of securing an ETD to submit the appellant full UK birth certificate. That reference at 219, what we say about that is if it was known that the appellant required a full birth certificate in order for the ETD to be secured, and he had been refused entry to Uganda because he produced his UK birth certificate, how do we say rhetorically, could it be concluded that his removal was reasonably in prospect on the basis that the appellant had completed an ETD application, the securing of an ETD being the only barrier to removal, which if properly completed would be refused?
Well, we don't know that. We know that the people in Uganda at the airport turned it back when late at night an immigration official was presented with a birth certificate. What this is all about, he's back in England now,
Yeah.
and the question is, what do we do next? You've shown us a document that says ETD removals were suspended, yes, so they were, but then they were reinstituted. They are now going to send the birth certificate, presumably, and the other information to the Ugandan High Commission to see if the Ugandan High Commission will give him the emergency travel documents. Because then if he's taken back to Entebbe with an emergency travel document, it'll be a different set of documents from what he had originally, which is an expired Ugandan passport and a birth certificate showing that he was not born in England. And what's wrong with the judge saying, well, okay, the judge thinks that's reasonable in the circumstances?
Because what we say about that is that if he completed the ETD application, which if properly completed would be refused, and if not completed would result in there no ETD in any event.
Why would it be refused, is the question.
Because of what had happened already, that when he was refused entry, having produced his UK birth certificate, we say primarily, how could it be safely concluded that the removal was reasonable on the basis that if he completed that ETD application, that would change the position? But alternatively, even if it wouldn't, and we say on the basis that wouldn't strengthen the argument the Ugandan authorities would take him, particularly what he'd already produced, but also the learned judge fails to grapple with this quite important issue arising out of the 11th of March detention review, because that was important, and the judge doesn't really, greatest respect, deal with the potential implications of that detention review in relation to the securing of an ETD. He needs to explain, in other words, why if it were obtained, the ETD, and were secured, why that could materially change the position in Uganda, on arrival in Uganda. More importantly, whether it was reasonable to keep the appellant in detention while that process was being contemplated.
What do you say about the significance of the April interview at the High Commission?
Give me one moment.
Paragraph 221 of the judgment. Claimant has a face-to-face interview at the Ugandan High Commission. No Home Office representative there, nor should there be. But Mr. Deakin is saying that why would they be doing that if it was already clear that there was no prospect at all of his being admitted?
Well, I think that comes back to the earlier point about two limbs of the respondent. Clearly, on one level, there was the point of an interview was to, I suppose, look into the position as to whether he was likely to be removed. But by that time, there was a lot of information the respondent already had to suggest that this was never going to be realistic in terms of his return. So we say at the highest, it simply emphasises the apparent lack of clarity in terms of the respondent's position, choosing to interview in April, knowing what they did know about the appellant by that time. There's one further point.
No, they didn't interview. High Commission.
Yeah. The interview, of course, was with the High Commission.
Yes.
And so the
Why
High
would they-
Commission interview, I'm so sorry.
Why were they bothering, as my lord says, to interview them if, according to you, what had happened in Entebbe meant that they were going to refuse it? They could have said there's no point interviewing him. He's got a British birth certificate, he's not going back. But they must have been interviewing him to see whether to grant an ETD. So it must have been reasonable to think they might get an ETD.
Well, my lord, we're not in a position to say my lord's not right about that. What we're saying is these were important issues to grapple. Indeed, there could have been a proper line of inquiry to analyse, to see what was the point of that interview. Did the High Commission, what was the point of the interview? We simply don't know the answer to that. And I don't think it's a safer inference necessarily that they were still thinking, the Ugandans were still thinking they might take him back.
But isn't it sufficient when one looks at the last sentence of paragraph 221 of judgment, which is Ms. Buckle understood that the issue was being referred to the authorities in Uganda. So the evidence before the judge, which he records, is that actually, even at that stage at least, the impression and understanding of Ms. Buckle was that the wheels were still turning, or thoughts were still being had, put it that way.
My lord, of course, I can't go against what Ms. Buckle said.
No.
But in my respectful summation, it's still important for the learned judge to have looked at the evidence post-return from Entebbe and see whether it was reasonable for the appellant to remain in detention throughout that process. He could perfectly properly, of course, been interviewed by the High Commission, but not necessarily be in custody at the time.
Doesn't he do that to 224?
Let's go to that.
Third sentence onwards. Given the criminal background and interest in the outcome, those are relevant factors, the defendant was entitled not to be persuaded by his claim that there would be no ETD, but rather to await, as my lady pointed out, the official outcome from the High Commission. They chased, and 5 days after the outcome had first been chased, they were entitled to conclude there remained a reasonable prospect. They chased again, and they came to say, well, we can't keep him there forever, and they let him out. Well, why isn't the judge, why isn't he grappling with it then? And that's his view.
because, well, of course I have to accept that 224 does look at the period previously, and I recognise that. But in our respectful submission, it's still, the question of the reasonableness of the detention still has to be seen in the context of the evidence which was available, all the
And
evidence.
he's come to review on that. He said, look at the risk, reasonable in the circumstances, give it another go and wait for the result. And you've got to show that that's wrong, and you don't dispute the primary facts. So where's the judge gone wrong, other than that you disagree with it?
Well, my lord, I don't think we can advance it further. Safe to say that the concerns are that there's still, in our respectful submission, he comes to a decision. Of course, we accept that, but the reasoning in our respectful submission, particularly when in paragraph 206, going back there again about how the judge used, I would respectfully suggest the word telling is pretty powerful evidence that he was going to follow it. That the complexities of the position in the period post-return, in those months, those 6 months or so until June, required a proper and careful scrutiny and analysis, and simply adopting, in one respect, inaccurately, in our respectful submission, the arguments and reasons that were advanced, is insufficient to clarify why the judge was entitled to come to a view that there remained a reasonable prospect of removal. So I don't think I can advance it any further. That's how we put our case in relation to that. And there are, we respectfully submit, an absence of findings in relation to the policy in relation to going back to Hardiel Singh 1, and I'm only just making the point shortly. He, at paragraph 190 of the judgment, at 1, 3 and 5, dealing with Hardiel Singh 1, in dealing with the Hardiel Singh policy, he doesn't link, the policy doesn't link in Hardiel Singh principles. You can see that. Again, what we say about that is that, taking shortly, and that's really, I think we've covered it, he doesn't do an analysis of the necessary requirements, both under Hardiel Singh 1 and 2, and separately 2 and 3, go over and beyond essentially adopting the submissions that Mr. Deakin advanced. They may well be well-founded, but there's a duty in our respectful submission for the judge to analyse the policy and can't simply just incorporate by reference, actually has to do more work to actually come to a reasoned decision, because obviously, as we all know, it's triad law. The loser needs to know why they've lost. And perhaps I can just finally, just the last thing I should tell you, is just re-emphasise that point in one authority, the case of which I'm sure the court is familiar with, English and Emery Reinbold. There's one passage.
We do know that. But,
I'm sure you do. Well, can I, just for the record then, ask the court please to look at, again, at paragraphs 18 and particularly 19 at page 316, which is about how the appellate process is to work satisfactorily to ensure the appellate court understands why the judge reached the decision. The fact that very properly some, if I may say, well-founded observations are made in this court and which we can't adequately answer is the point in our respectful submission as to the failure of the judge in appraising the evidence, identifying what the relevant parts are, and explaining not simply why he's not simply that he is adopting submissions, but explaining it properly and clearly so that the court understands. And I'm finished with this. And we haven't stressed it, but that is particularly important when there's a substantial delay, as everyone accepts here, that we understand, the loser fully understands, in this case the appellant, how it was that the Hardiel Singh principles, policy matters were properly addressed, in concluding that Mr. Dean's submissions were well founded. Unless I can assist the court any further.
Thank you very much.
So, sorry, my lord, I don't mean to respond, but there's just one point. You asked what cross stood for.
Sorry?
And
Oh,
you
you
asked-
you started the sentence. Yes.
It stands for Country Returns Operations and Strategy, and it's now Returns Logistics.
I thought it might be, yes. So it's the same one, same people, different name. So country,
Country Returns Operations and Strategy. Miss Buckle deals with it at page 25C.
Now known as,
Returns Logistics.
yeah,
Sorry about
but it's
that.
the same people actually with a different name on the door.
That's what it appears to be.
Yeah.
thank you all for your assistance, both oral and in writing. We will reserve judgment. We will send out a draft judgment in the usual way. Council are well familiar with this, but I have to say it anyway. 2 points about the draft judgment. We're sending it out for correction of typos and obvious errors of fact like misstated dates and so on. We're not sending it out for re-argument. Secondly, the contents are confidential until the hand down to the claimant, and on the Home Office side, those involved with the case and those who need to know. I put it no more widely than that. Thank you all for your assistance.